Good day, and welcome to the Employer's Guide to Security, Privacy, and Compliance Training. All phone lines are in a listen-only mode. You may enter your questions through the Q&A window located on the platform. Please be advised today's program may be recorded. It is now my pleasure to turn the program over to Gary Bossert. You may begin.
Hey, thank you, Aaron, and good morning, everyone. My name is Gary Bossert. I'm the Vice President of Operations for the Medical Society Plan and Curie Benefit Solutions. Thank you for attending another NCMS Plan Employment Law webinar. This is one of a quarterly series of webinars we present exclusively to NCMS plan practices. We select topics not specifically related to employee benefits, yet what we believe are relevant to your work. I know that you fill many roles in your practice, and titles can vary, but one thing is common. You have some responsibility for the management of the staff in your practice and the policies in place. It's been 24 years since HIPAA was signed into law. Designed to protect the privacy, security, and integrity of PHI, the law has been difficult to comply with and requires practices to have specific measures in place to safeguard this information. Combine these challenges with a global pandemic, and practices are stretched thin as they work to ensure their organization is fully compliant. Shifts in virtual work and a rise in telehealth appointments seemingly happened overnight, leaving many healthcare providers and related organizations unprepared. These types of occurrences can leave both small and large organizations vulnerable to outside and inside threats, as well as reputation-damaging fines. Even with the most advanced technology, an organization's defenses are only as strong as its weakest link, which can often be the people on the front line accessing data as part of their day-to-day job. Practices must remain vigilant in providing adequate proactive education on what following security best practice fully means. By implementing the right procedures and training, an organization can ensure their people are equally prepared to defend against attacks and ultimately avoid falling victim to a data breach. This is the time for practices to get a better grasp on compliance and continuity across their organization. Today, we will explore how to achieve this. We are fortunate to have an attorney from the law firm Nelson Mullins with us today, Ann Murray. Ann is a partner in Nelson Mullins' Atlanta office, where she practices in the areas of employee benefits and executive compensation. She is a member of her firm's healthcare team, which focuses on providing comprehensive services to hospitals, physician practices, and other healthcare providers. Ann assists her clients with all types of HR and benefits-related matters, including those relating to qualified retirement plans and health benefits. As Aaron said at the top of the presentation, if you have questions during the presentation, you can type them in the Q&A window, and Ann will respond at the end. Ann, thank you for presenting for us today. The line is yours.
Thank you, Gary. And thank you, everyone, for joining us today. I know that things are a little crazy these days. We're thankful that you could take the time out to learn a little bit more about what training might be needed and sort of sharpen your information technology protections within your business. What we intend to cover today, as you'll see on the slide, is the importance of information security in the healthcare industry, what privacy and security training is needed for your staff and how often, and recent updates and current trends, as well as how you can minimize your liability risk. I think many of the organizations that are listening to us today and attending, you focus on OSHA, Stark, false claims, patient inducement, and a lot of other laws that are geared towards who can get medical services and how it's delivered. But a lot of times, information security tends to take a bit of a back seat or is expected to be handled by the IT person or IT department and really isn't viewed as part of the overall sort of first line of defense. So we're going to talk today about why that shouldn't necessarily be the case and why it's important to take some steps to check the box that you've trained your workforce properly to comply with not only HIPAA but several other applicable laws that we'll discuss. So, why is it important to focus on security? I think we all know healthcare organizations, you hear it all the time in the news, have become a target of a significant number of cyber attacks in recent years. These are growing annually. Back in 2015, Congress even recognized this, and they ordered that the U.S. Department of Health and Human Services establish a task force, what they call the Healthcare Industry Cybersecurity Task Force. And the intent was that would help to maybe quash the dramatic escalation that Congress recognized was happening in cybersecurity attacks against the healthcare industry. That task force in 2017 issued a report where they focused on the readiness of the workforce and recommended, increased healthcare industry readiness needs to happen through improved cybersecurity awareness and education. And they stated that the susceptibility to cyber threats exists for many organizations because most people within those organizations are neither aware of the risk nor have the tools to protect their systems. And so part of what the task force recommended was that a baseline cybersecurity understanding needs to be developed at all levels within an organization. So compliance can not only avoid penalties and lawsuits, but it also may preserve rights to certain government benefits. In June of 2017, the HHS Office of Inspector General recommended to the Center for Medicaid and Medicare Services to recover an estimated $729 million in improper electronic health record incentive payments from organizations that weren't complying with their information privacy and security requirements. Part of that is the HIPAA training, risk analysis, and other compliance that's required. And they cited that if someone, for example, isn't complying with the HIPAA risk analysis and other HIPAA requirements, that they don't satisfy the, quote, meaningful use that's required in order for someone to qualify for those electronic health record incentive payments. So there's more than just, your standard HIPAA penalties at risk. That's some $729 million in total is certainly a meaningful amount of money. Because you're in North Carolina, another reason to focus on this area is it has been recognized by, Attorney General Josh Stein. He stated when he was originally elected that protecting the people of North Carolina, including their data, is a top priority for him. And it's his duty to hold companies accountable when they fail to uphold the privacy standards of North Carolina. In January of 2020, he announced that North Carolina had seen a record number of data breaches reported. So in 2019, looking back, nearly 1.1 million North Carolinians were affected by 1,210 data breaches. That's a sizable number. And that's certainly, while not in the healthcare industry, last year's data breach settlement with Equifax, and the state of North Carolina was the largest ever settlement in history. So this is definitely an area where, it continues to grow, and we need to make sure that, while you certainly need to focus on the services you're rendering and patients' health, we also need to make sure that we're protecting them in other ways. Their personal information needs to be properly secured. As they say, prevention is better than cure. So what privacy and security training is needed within your organization and how often? This certainly is going to depend on the size of your organization. Do you have only a few people? Do you have hundreds or even thousands? A lot of that is going to be facts and circumstances, and it's not going to be one size fits all. But how often? At a minimum, you should be having information privacy and security training at least at hire for those who are expected to come into contact with this information, which, quite frankly, is probably almost everyone nowadays. I see a lot of my clients just falling back and saying, you know, we used to just limit it to certain groups within our organization, but now it's just better to just have everyone upon hire needs to go through some sort of information privacy and security training. And then at least annually. Now, I know everyone doesn't do it annually. I do have clients that perhaps have a refresher every other year, or they may train annually but do a smaller kind of quick refresh course, maybe online that someone does on their own. But the ideal and the best practice is to show that you're training at least annually. And then always remember, whenever organizational changes are made that impact the obligation. So, for example, and we always talk about this in HIPAA training, if your organization moves, you know, you're in one building and now you move to a standalone building, or from a standalone to a larger building with other tenants, there are reasons that you need to take your staff needs to take different steps to protect the information. So focus on anytime you open a new location and now you're sending information back and forth, or you have a new outside records vendor and you're going to be shipping information back and forth, or you get a new IT system. All of those types of changes impact how you store and use information, and so therefore you need to focus on, do we need to tweak things so that everything's being properly protected and we don't have some gaps. So training should always cover the importance of information security in your business, in the healthcare industry, in understanding and complying with HIPAA rules, but also understanding and complying with state laws, so North Carolina's laws that protect employee and patient or customer information. And then for certain employees, you may need to have additional training and make sure that they understand when other protections might be triggered, like, fair credit, all of, well, we're going to talk about those, but there's a lot of different laws that can affect, those that are handling your credit cards, those in HR that might be running background checks, and they may need training and compliance guidance there. And then understanding and complying with whatever security and privacy policies you have in place. And we'll talk more about what you should have and the requirements that apply. The benefits of an effective compliance program, besides avoiding penalties, it's also just going to demonstrate your commitment to responsible conduct. It certainly is going to reinforce with your employees that you focus on this, the protection of patient and employee information, and that this is a priority. Let's talk first about HIPAA. For many of you, you've been dealing with HIPAA for years. I know sometimes it's the bane of your existence because it's not only just getting things signed when patients come in, but just dealing with how it restricts your ability to discuss and share information as you may think that you need to. So the Health Insurance Portability and Accountability Act, been around now, for going on, 15, 20 years here, protects the privacy and security of protected health information. So this is the one where you're focused on your medical records and personal health information, protected health information that identifies the individual, or it doesn't just have to be the individual by name, even if there's a social security number or an address, something that could give someone a reasonable basis to identify the individual, that makes it protected health information. And so, if you have spreadsheets, you have reports, you have files that may have names redacted, don't assume that they don't also need to be protected. But that's where your employees need to realize, and your workforce members, it may not just be employees, always think about contractors that you may also be hiring. They need to realize and recognize when they need to apply HIPAA protections. Training is specifically required by both the privacy and security rules of HIPAA. Training materials, I could say if you want an easy resource, there are training materials available on the HHS website. If you go to hhs.gov/HIPAA/for-professionals/training, there's several different guides and training materials that you can use and incorporate into your workforce's training. Also, don't forget whoever is handling your different filings should be calendaring things like HIPAA breach reporting deadlines, and people within your organization should realize when they need to be filing reports. Those reports are due February 28th, by the way. But that's certainly an important feature. Now let's talk about North Carolina's laws. On the North Carolina side, we have the North Carolina Identity Theft Protection Act. Now that act applies to all businesses, both nonprofit and for-profit. It protects the dissemination of certain personal information, such as Social Security numbers, but it also prohibits you from emailing or printing a Social Security number on anything that you might mail. So you need to be focused on whether it's electronic, email, or it's on paper. You don't ever want to be sending something out that contains any of the prohibited information under the North Carolina Identity Theft Protection Act. You're required to use reasonable efforts to protect this information, and you have a duty to not only protect it while you possess that information and while your workforce is working with it, but also how you dispose of that information. So in training your workforce, you're going to need to focus on, make sure that they recognize what is protected by the North Carolina Identity Theft Protection Act, but also, okay, if let's say they're hiring a third party that stores your records or disposes of your records, they need to make sure that they're properly complying with the requirements that have to be satisfied. And there's specific requirements set forth in the Act relating to hiring third parties for records disposal. So I encourage you, if you have people who are out there hiring outside vendors, make sure that part of their training is that they recognize, okay, here's the things we have to have in our written agreement with those companies. You also need to make sure that people that would be handling breach notifications are properly trained, that the North Carolina Identity Theft Protection Act requires certain written notifications to the state attorney general's office. Those are some of the notifications that when I was talking earlier about Mr. Stein's announcement of so many breach notifications being filed in 2019, this act is what requires those filings. Now, there's currently efforts underway to amend and strengthen this act. They tried to pass some more stringent requirements in 2019. Those were not successful, but the efforts are continuing from the State Attorney General's office, so it's certainly something to stay tuned to see how these requirements may, to recognize when these requirements are strengthened and then incorporate any of the changes into your training. Also note, North Carolina does have a law that says that any person not authorized to have access to a personnel file who knowingly accesses it may be guilty of a misdemeanor. So even on the HR side, you need to make sure that HR personnel is aware of who they can share personnel files with, when to properly respond to requests for personnel files, and are aware of those laws. Okay, other laws that might protect patients' information as well as employees' information, and for which you may want to provide some training to specified portions of your workforce, are on the slide in front of you. Let's go through them. Fair Credit Reporting Act. Now, we're all familiar with FCRA if we're out there, opening a bank account or buying a car or dealing with, our credit card company. But you may not think about it as impacting your organization. Well, it does. It protects privacy and accuracy of consumer and credit report information. And so if you obtain consumer reports as part of background checks in your hiring process, you need to make sure that your HR employees are trained on the FCRA. They need to be providing proper notices and obtaining proper sign-offs from applicants and employees. There have been some significant penalties assessed under the FCRA to many large companies where their application materials just didn't comply. So you need to make sure that whoever within your organization is dealing with job applicants and the hiring process recognizes and is trained on when they need to comply with FCRA and how to do so. The next area is the Gramm-Leach-Bliley Act, GLBA. I mean, this one's been around since 1999, and although it's 2 decades old, many organizations that are subject to the GLBA don't recognize that they are. The GLBA regulates the collection, use, protection, and disclosure of consumer non-public personal information by financial institutions, and that's a defined term, and companies who receive non-public personal information from financial institutions. It's this definition of financial institutions that may make the GLBA apply to healthcare organizations. It's a lot broader than you might realize. So the GLBA defines a financial institution as any institution that's, quote, significantly engaged in financial activities. Some of these financial activities are things like lending money and providing consumer financing. So if your organization allows, let's say, long-term payment plans on which interest is routinely charged and maybe memorialize it in a written contract, and if a significant number of your patients take advantage of this type of plan, then your organization could very likely be subject to the GLBA. Or in addition, even if you determine that you're not within that financial institution definition, you might still be subject to certain obligations under the GLBA if you receive the non-public information from non-affiliated financial institutions. So, for instance, once again, back to the credit reporting agencies. If you receive information from credit reporting agencies on new hires, or, and this also relates to the FCRA, if you run patients' credit before offering them certain financing, then you could be triggering GLBA obligations as well as FCRA obligations. So in that case, if it is possible that you may be subject to the GLBA, then you're going to want to make sure that those people working in your accounting, finance, accounts receivable department are aware of their obligations and making sure that they comply and ensure the security and confidentiality of customers' data. The next category is the Payment Card Industry Data Security Standard. Whew, that's a mouthful. The acronym is the PCI DSS. Basically, the PCI DSS is a set of regulations that is supposed to protect credit card information. So much like the FCRA and GLBA, this is another area where those within your organization who are accepting payments, your accounts receivable department, or those people who are handling patients as they leave and processing their credit cards, need to be aware of their obligations under the PCI DSS. Anytime you're handling, transmitting, storing credit card information, there are compliance obligations that apply under this law. Now, these are just 3 examples of possible areas where you need compliance training for your workforce. You need to think about, how you use different data and information And are there additional steps that you need to be taking or additional laws that you need to be worrying about achieving compliance? As I said earlier, one size definitely doesn't fit all. You know, it may be that you branch into some other areas that, for example, if you work with governmental agencies, there may be government privacy requirements. Even at the state level, North Carolina has specific requirements that apply to state health agencies, but they also may kind of have that trickle-down effect where they apply to organizations who contract with the state agencies. So kind of think about how you fit into, you know, kind of that supply chain. So who needs to have privacy and security policies? You know, written policies, as I said, are specifically required by HIPAA's privacy and security rules. But none of these other laws, whether it's the North Carolina law or the FCRA or you know, all these different acts, do not specifically require privacy and security requirements. However, since they all require that reasonable steps be taken to achieve compliance, certainly some type of written privacy and security policy is a good idea. We generally recommend it. We think that not only should your privacy and security policy cover your HIPAA obligations, but also make sure that even if it's just an appendix or something at the end, it should also mention your compliance with North Carolina's rules as well as any of these other laws that may apply. If you aren't already having your workforce acknowledge that they've received a copy of your written privacy and security policies, we recommend that you do so and file it with your personnel records. You know, this is part of the ongoing training, and you should be able to show that each and every person within your organization has not only received training, but has access to your current policies. It'll also help when and if you have anyone who violates your current policies, and you can show that they have received the written copy of the documents and should be aware of what those requirements were that they have now violated. Note, if you do have written privacy and security policies, and I have clients in this situation who, you know, they put them in place back in 2004, 2005 when, you know, they were first doing their HIPAA compliance, but quite frankly, they have never touched them again. It's probably time to pull them out and dust them off. As part of your compliance training for your workforce, before you hand those policies to everyone, make sure you go through and read them and see, does this really make sense with how my organization currently works? I mean, a lot has changed since 2004. And so you need to make sure that if your locations, your systems, how you store information and all of that, if anything has changed, your policy should reflect that. You know, many people are out there now storing data and information in the cloud. You know, if you are, then there should be something in your written policies that reflects, okay, what do we do when we, you know, upload information into the cloud, download information, or what steps do we need to take with our cloud vendor to make sure that they have in place appropriate, you know, security. These are all things that whoever in your workforce is hiring the vendors and dealing with this information, they should be receiving training that covers this. And part of what they receive in the written policies and procedures should address, you know, how you're operating. Make sure everything's up to date. And we talked at the beginning about making sure that as organizational changes happen, that you go back and revise your training. Also make sure that you're going back and revising your privacy and security policies. So there have been a lot of updates, especially with, you know, COVID these days. Let's face it, you know, a lot of things are changing. And so we've seen updates from various federal and state government areas relating to information security. So let's talk through a few of those. Certainly COVID-related guidance has been issued by the Departments of Health and Human Services. We see it from OSHA all the time, various government agencies. Health and Human Services has a specific website location where you can go to see any of the special COVID topics. We've got a link there on the slide, so if you want to go visit that site and see all of the updates, use that link. But they've also come out with some guidance that we wanted to highlight. For example, they've relaxed certain rules. In April of this year, the Department of Health and Human Services released guidance that authorizes pharmacists and certain other, small vendors to order and administer COVID-19 tests. And on April 9th of 2020, the Department of Health and Human Services Office of Civil Rights announced that it won't penalize covered entities who act in good faith in operating COVID-19 community-based testing sites. So these waivers don't give carte blanche to do whatever you want. What you need to do is make sure that you're establishing your good faith compliance. This means you have to have your staff properly trained. They need to know what any of this relaxed guidance is that may apply to you and to them, and that they are complying. They need to know what's permissible, what's not permissible. Another change that has come down the road recently is in March. I think it was March 27th or 28th, I think. The CARES Act was issued and made significant changes to confidentiality requirements that may apply to substance use disorder records. So if you work with or have a portion of your staff that works with substance use disorders, then you need to make sure that you're keeping tabs on this guidance and that you're properly training those workers. The guidance in the CARES Act basically said, hey, substance use disorder confidentiality requirements used to be much more, or have historically been much more stringent than the HIPAA rules that apply to other types of medical records. The CARES Act is seeking to move the substance use disorder rules so that they're much closer to the HIPAA requirements. We're supposed to see the Department of Health and Human Services issue new regulations within 12 months of the CARES Act that are going to sort of relax these substance use disorder records rules. And so stay tuned, because as those are relaxed, that's going to be the type of change that you're going to want to make sure that you are training your workforce on, and anyone that deals with those type of records is aware of, when they can disclose, when they can't. It'll no longer be, substance use disorder used to be limited to like one or two emergency situations. If it moves to being the more general HIPAA rules, then there's going to be the ability to disclose to not only law enforcement, but also, treatment, payment, and healthcare operations, meaning that you'll be able to share with other providers and with other, insurance companies. So that may be a big change. Note that what's interesting was the CARES Act actually did add one thing that made it more stringent on substance use disorder, and that was they added an anti-discrimination provision. So you cannot discriminate against someone where you have their records indicating that they have a substance use disorder. So that may be something that you want to make sure that your workforce is trained on, so that someone is not inadvertently, looking up someone's record and taking steps to, deny them some right that they should be entitled to and shouldn't be able to. They should not be discriminated against. So what do you need to do to minimize your liability risk? I mean, just to sum up what we've talked about on the training side, first, before you even move to the training step, you need to make sure you've got written policies in place. Make sure your policies are also provided and available to your employees and contractors and are available for reference. As we talked about, the policies need to cover not only HIPAA, but if all you've got is the HIPAA ones from 2004, pull them out, dust them off, and make sure that they're updated to reflect the North Carolina rules and some of the consumer credit protection rules, as well as what we talked about on the substance use disorder rules. All of those things need to be reflected in your policies. Make sure they're understandable too. Not a bunch of legalese, but written so that they, as your employees are reading the policies, they're easy to find answers in, and they're written in, relatively speaking, in plain language. Consider having your employees, as we recommended, sign an acknowledgement that they received a copy of the policies. You may even want to go an extra step and just to kind of ingrain it in their minds, have your employees sign off on some type of sort of certification or, I pledge that I will comply with confidentiality requirements and not violate any of these rules. While it's not like getting them to sign something, makes it so, it can go a long ways towards just reinforcing their obligations and that this is something serious that they need to consider. This is my time to harp on HIPAA compliance. If you have not already done so, make sure you have a HIPAA privacy officer and HIPAA security officer appointed. And in particular, if you haven't revisited this in a while, make sure those people still exist within your organization. Okay, I can't tell you how many times I'm talking with clients and they have someone that was appointed by name, Jane Doe, and Jane Doe left the organization 3 or 4 years ago, which also says they haven't been doing anything to follow up on their HIPAA compliance in 3 or 4 years. You can name your HIPAA privacy officer or security officer by title. That may be a better route, or have a backup. So if you name someone, and this is what we do a lot of times in our policies, is we'll name a certain individual that's currently employed, but then have a backup that says, but if that person is no longer with us, our privacy officer will be the highest ranking HR person, or, our security officer will be the highest ranking IT person. That at least puts it in someone's lap to be responsible for. Now, you also need to communicate, and they need to know that they have those obligations, but, at least this checks off one requirement. Note that it has to be one single person when you appoint a privacy officer or security officer. If you have named some committee, for instance, if you have a security committee or IT committee, you cannot have more than one person serving as your privacy officer or serving as your security officer. I mean, you can have 2 different people, and that's very common, as, Jane Doe is your privacy officer and Tom Smith is your security officer, but I'm saying you can't have both of them serve as their own committee. Calendar to review and update your policies regularly. Just put it on for once a year, and put it on for around the same time that you're going to do your training. That way you can update your policies immediately before training commences, and you know that what you're communicating to employees is the most accurate and up-to-date. And then identify where protected information is created and retained. If your organization has changed, revisit where is all of the data and information. Are you using, a third-party vendor for this? Is there a file closet somewhere? Where is the information, and how much of it is in electronic format? And if it's in electronic format, what steps do you need to take to protect it? And then conduct your training. At hire, ideally once a year, even if it's just a refresher, and definitely anytime your organization has an internal change or a change in your IT or even your outside vendors. If there's a different flow you're going to have to use for transmitting information, or maybe to the insurance company. That could be another category. And then as part of your training, it's always a good idea, not necessarily as a scare tactic, but make sure that you communicate and are applying sanctions for violation of your policies. You know, employees and your other contractors need to recognize that, you know, just as you do with OSHA and some of the other, you know, Stark laws and other things that are so important in the healthcare industry, they need to recognize that the information privacy and security is just as important. Okay, now I think we'll open it up to questions if we have any. I don't think I see any in the Q&A box at this point, but Gary, do you have anything?
Yes, there is one question. The question is whether consent forms are considered policies, and I think this is a reference back to slide 10. And I believe the question is whether having a consent form signed, does that replace the need to have a formal policy, or do you have to have a formal policy that is referenced in the consent form? Does that make sense?
Yeah, that makes sense. And I think that, you know, as part of, I think, and I'm just going to make an assumption here, if we're talking about, let's say, our typical consent form that we all get as healthcare professionals when the patient comes in, or if an employee asks for information, you may get them to sign a consent form. That itself is one of the many things that should be addressed in your HIPAA privacy and security policies, but the consent form alone it is not a policy. And I think that if that's all you're using, then I definitely recommend taking a step back. And you know, there's tons of this doesn't have to be a massive undertaking, but you need to have policies in place that not only, you know, the first step with HIPAA is you have to have done a risk analysis that helps you create your policies, and your policies should address all the different ways that you have data and information within your organization and how it's going to be protected. There's lots of forms out there. It shouldn't be something that you have to create from the beginning. But you definitely, one of the things that's in a policy would be, listen, before any patient comes into our organization, we will have them sign a consent form as part of the intake process. Or if a patient or employee requests protected health information and wants us to transfer it to, you know, another doctor or another facility, we will have them sign a consent or authorization form, and here's a copy of that at appendix whatever. That's the way I would envision the policies working.
Very good. So then there's a question about sample policy forms for employees. And yes, I would think that, and I guess it depends on exactly what type of form, but if you are a Curie medical malpractice insured client, you could certainly contact our risk management department, and I'd be happy to provide that contact information offline for anybody who wants to reach out to me. But they do have a library of consent forms that they use, that they provide to practices to use with patients. If that's the specific question or specific form you're looking for, we can certainly do that, and I can make that connection for any of you that are interested. That, I believe, was the last question. On your screen now, you should see a pop-up that will allow you to download today's webinar, the PowerPoint that Ann shared. We will also provide a recording of this. Should be mounted on our YouTube channel probably next week, so you can keep an eye out for that. And Ann, is there anything else that you want to add before we conclude?
No, I think that's it. I think it's my only point on the compliance and information protection is, you know, I think don't get overwhelmed. It's, you know, just at least having something in place is better than nothing when it comes to audits from the government or any type of inquiry, because when a breach happens, and it will eventually for almost everyone just in this day and age, when a breach happens, you want to be able to say, hey, we took steps to try to prevent this. And the worst thing to have happen that we see just from penalty perspective and the government coming in is if they come in and something has happened and there isn't a shred of any type of evidence of having implemented policies or trained the workforce, they're going to come down a lot harder and be a lot less forgiving. So it's just a good step to take.
Great tips, and this is a great presentation. Thank you for the information, Ann. Appreciate your help with another great webinar. We'll probably be conducting another webinar. This is likely the last one for 2020, so probably the next one will be in January of 2021. So watch for that invitation. Hope everybody has a great day. Thank you again for attending. Take care.
Take care. Bye.
Thank you for your participation. This does conclude today's program. You may disconnect at any time.